Justice Gorsuch?
I just wanted to understand some of your responses or efforts to respond to some of the questions that we've heard today. As I read your briefs, you thought Idaho thinks that in cases of molar and ectopic pregnancies, for example, that an abortion is acceptable.
Correct, Your Honor.
And the example of someone who isn't immediately going to die but may at some point in the future, that would be acceptable.
It goes back to the good faith medical standard, but yes, if the doctor cannot determine in good faith that death is going to afflict that woman, then no.
So it doesn't matter whether it happens tomorrow or next week or a month from now.
There is no imminency requirement. This whole notion of delayed care is just not consistent with the Idaho Supreme Court's reading of the statute and what the statute says.
And the good faith, as I read the Idaho Supreme Court opinion, that controls. That's the end of it.
Absolutely, it is.
All right. And then what do we do with the EMTALA's definition of individual to include both the woman and, as the statute says, the unborn child?
Yeah, we're not saying, Your Honor, that EMTALA prohibits abortions. So, for example, in California, stabilizing treatment may involve abortions consistent with what that state law allows its doctors to perform. But I think our point with the Unborn Child Amendment in 1989 is that it would be a very strange thing for Congress to expressly amend EMTALA to require care for unborn children. And it's not just when the mother is experiencing active labor. The definition of emergency medical condition requires care when the child itself has an emergency medical condition, regardless of what's going on with the mother. And so it would be a strange thing for Congress to have regard for the unborn child and yet also be mandating termination of unborn children.